is a special series because this series is focused on the complainant and the respondent and their roles in an IC inquiry. So what we have decided to do is to provide information for the complainant and the respondent in terms of what they should be doing in the context of a hearing or an IC inquiry. The first of the three-part series is focused on the complainant, which is basically how does a complainant draft a complaint, what are the things that go into it, what are the nuances, what kind of evidence should be provided to the IC in the complaint, and so on and so forth. So the idea is to provide the complainant with enough information in order to be able to draft a comprehensive complaint. The second part will focus on how to draft a response, which is basically from the respondent's perspective. When they receive a complaint, what is the way to go about drafting an appropriate response? And lastly, for both parties, we are going to have the final session on what is the procedure in an IC inquiry. How do you conduct examination, cross-examination? What is the IC process? All of those things, so that when somebody, either a complainant or a respondent, goes into an IC inquiry, they know exactly what to expect. Although some ICs may have slightly differing methods or processes or procedure, that's all right. But largely, when you walk into an IC hearing, you should be able to figure out, or you should already be prepared for the process and the way in which that process will run. So that's the three-part webinar series that we have got for you. Today, as I mentioned, today is the first one on how to draft a complaint. And before we kick off the series, I wanted to introduce a guest. We have a very, very special guest today, a friend of mine as well, a really old friend, and a special guest, Veena Gowda. She's a women's rights lawyer. She graduated from National Law School in 1995 and worked at the Bombay High Court and the Family Court, initially with Mumbai-based Legal Aid Center for Women. And thereafter, in 2005, she had established her own independent practice and has secured justice for hundreds of women in cases of domestic violence, sexual harassment at the workplace, sexual abuse, and property rights cases. Veena currently has a team of lawyers working exclusively on women's legal rights, and teaches a course on engendering law and justice at the Tata Institute of Social Science. So very, very eminent, very well-known figure, personality in the arena of women's rights. So allow me to welcome Veena. Veena, great to have you for our session today, and welcome.
Thank you, Anthony.
So we'll get going with our webinar. We're going to start with what is a complaint, what is the basis, what really goes into a complaint. So very simply put, a complaint is any allegation of, in the context of sexual harassment, any allegation of sexual harassment made by the complainant, orally or in writing, against a person who may be known or unknown to the complainant. So essentially, the elements are that it could be oral or in writing, and it could be against a person who may or may not, who may be known or may not be known to the complainant. Most importantly, it has to be an allegation of sexual harassment. The second part that all complainants and prospective complainants should be aware of is that under the POSH law, all complaints have to be made to the IC in writing. So the POSH law, the Prevention of Sexual Harassment Act, which was passed in 2013, clearly stipulates or mandates that all complaints have to be made to the internal committee in writing. So which essentially means that anonymous complaints or oral complaints cannot be accepted by the IC. But of course, I'm sure Veena has something more to add to that. So we'll come to that in a bit. And the second part that one needs to be mindful of is that if you have spoken to your manager or an HR representative, then they have a duty to share the contact information of the internal committee with you, so that you are in a position to write, draft, and forward your complaint to the internal committee or the IC, right? Lastly, if the complainant is not in a position to make a written complaint for whatever reason, maybe she's not in a position, maybe she's cannot draft the complaint on her own, needs assistance, whatever it may be, the IC, as per the POSH law, must take reasonable steps to assist her. So this is basically what the POSH law 2013 has mandated, that the internal committee is required to support or assist the complainant in the event she's unable to make a written complaint. So that's the sort of the broad framework of what constitutes a complaint under the POSH law. Veena, anything to add to that?
Yeah, Anthony, thanks a lot. First of all, I think what Anthony has done is told us in brief what a complaint of sexual harassment is. But what's very important to understand and to remember is that often women tend to be very intimidated, and the very process of to file a complaint intimidates them or scares them. So at the outset, women ought to remember that don't be intimidated by the law. Just understand the simple, basic principles of it. This is not in a way of going to a court or drafting a legal petition. So what the law envisages or what the law intends is that women should be able to put down their complaint in writing of sexual harassment. So whatever the experience of each of us may have been, if we have faced sexual harassment, to be able to, in a simple language, in the best known possible way, that we write it down. Okay, and one is that if you can see on the slide, it says a known or an unknown person. Okay, so one may wonder why is it that they've added one unknown person. How does complaint work? Because sometimes what happens is that we have seen that they may be digital stalking through online stalking, etc., where the woman feels or knows that it's possible it could be someone in her office, but is unable to pinpoint who it is. So then she should also be given an opportunity to at least approach the IC and see if some kind of an investigation can be made to see who it is, if it's someone from the office. Because the entire purpose of the law, the purpose of the sexual harassment law, is to ensure that there is a safe workplace for women. The whole purpose of the law is drafted such that the possibility of filing a complaint becomes accessible to women. So it should not end up being intimidating to women. So one, to be able to translate our experience of women of sexual harassment into a complaint. So it has to be written. So because as Alex said, the next session will be about a reply to be filed by the respondent. So the respondent or the person against whom the complaint is filed also has a right to know what the complaint against that person is, because he too has a right to defend himself. So therefore you say that it has to be written, it has to be a written complaint. The law also says something like 6 copies of the complaint, etc., has to be given when you read the complaint itself. But I think we need not get too worried about that, because that's a very old-fashioned paper and pen kind of a complaint which the law envisages. But if you are allowed to send it out on emails, because many of the ICs and companies have email addresses to which you send it, etc. So therefore, those of 6 complaints, etc., is not really so relevant today. And the IC also cannot say that, oh, we received only 1 copy, therefore we are not initiating the process.
Right.
So just write down your complaint, send it across. Now, sometimes what happens is that the experience of sexual harassment is so traumatic to a woman, and she may be very emotionally disturbed, so is unable to write down the complaint. So then the law also, that's why the last part of this slide, that the law says then the internal committee must assist the woman to be able to write it down. Sometimes it may be such that, in certain circumstances, the woman is admitted in hospital, is mentally challenged, therefore cannot write the complaint. So in such cases, the woman can also then somebody on her behalf to actually file the complaint, but then she will have to give her consent, or the IC has to confirm that yes, it has been done with her permission.
Understood.
Or with her knowledge.
So one very interesting aspect of the law, Veena, is that the IC is also mandated to follow principles of natural justice. which essentially means that both parties have a right to be heard. And I think that's a point of reassurance for all parties to to this entire process, right? In the sense that the IC cannot pass an order without hearing both parties or affording an opportunity to both parties of being heard. So they can be rest assured that they have to be heard before the IC passes an order.
Yes, and secondly is that of course the respondent also should be heard, but sometimes what committees do is that when they receive the complaint, just based on the will say that okay, I mean there is a substance in this or no substance in this. So now if a woman files a complaint of sexual harassment or the complaint is received by the IC, and it may seem that at the face of it that there is no element of sexual harassment in it. It could be possibly a work-related harassment or right. Something else. So then the committee then has to also can't just ignore it. They will have to then say that okay, this does not come within our ambit, and send such a reply to the complainant. And right. She also, and if she's filed such a complaint, I would think that the IC should also speak with her, and say that okay, this is what it is. So therefore, the whole process cannot be cloak and dagger kind of a situation.
Yes, that's the important aspect.
Has to be transparent.
Got it.
If I file a complaint today, if the committee feels that this does not amount to sexual harassment, I should at least be given an opportunity to say then why I filed it as harassment. Because sometimes what happens is that women are a little hesitant, and they may say that he was abusive to me or he abused me. And now that abuse may have, yes, and that abuse may have a sexual connotation, implication. So therefore, it's fair that the IC must at least give that hearing even to the committee. So,
in a nutshell, if a complainant's complaint has been rejected by the IC simply, on the basis that the IC doesn't believe it is a complaint of sexual harassment or sexual in nature, the complainant has a right to be heard and therefore has the right to go to the IC and say, please hear me out before you dismiss my complaint. She has a right to ask for that.
Yes. Yes.
Understood. Okay. Terrific. So now that we've established what a complaint is, we can dive a little bit into the timeline for filing a complaint. Under the POSH law, and this is very, very important, under the POSH law, a complaint must be filed within 3 months from the date of the incident. And if it's a series of incidents, meaning if it's a series of incidents that's happened over a period of time, then within 3 months from the date of the last incident. This in law is called limitation. So it's very important that as a complainant, you have to file your complaint within the limitation period, which is essentially 3 months from the date of the incident or the date of the last incident, if it's a series of incidents. Now, within this 3 months, if you file your complaint as a complainant, you have a right to be heard, which is the IC does not have any discretion to turn you down, unless, of course, they feel that this is not a case of sexual harassment or there is no sexual intent in what really happened. However, in the event that the complainant, for whatever reason, is not able to file the complaint within the first 3 months, that is 3 months from the date of the incident or incidents, then the law provides for flexibility, which means that the IC has now the discretion to hear the complaint if the complaint is filed within the next 3-month period, which is to say that within the first 3 months period has elapsed and the complaint has not been filed, but in the second 3-month period, the complaint has been filed. Here, though, it is very important to note that it is at the IC's discretion. And so only if the IC is satisfied that the circumstances were such that prevented the complainant from filing it in the first 3-month period, could the IC extend it and allow them to file it or accept the application if it is filed in the second 3-month period. So that's limitation. It's very, very important. Just to sum up in terms of, just to be absolutely clear, if the incident of sexual harassment happened on January 1st, then the complainant has until April 1st to file the complaint and the IC must hear the complaint. But if the complainant for any reason was not able to file it between Jan 1 to April 1 and has ended up filing it on, let's say, May 15th, then you as the complainant must remember that you no longer have a right to be heard, and that the IC has the discretion to accept your complaint. So this is a very, very fine distinction that that must be borne in mind by a complainant at the time of filing a complaint. Veena, is that is that correct, and would you like to add to that?
That's correct, but at the same time, I would say that one thing to remember is when you say series of incidents. So it not to my see, we need to understand that this law is still very young law, or a very nascent,
Yes.
at a very nascent stage. So it's not to that extent that the courts have laid down all principles already in every aspect of it. And being a social welfare, welfare legislation in that sense, the interpretation of the law must always be in favor of the person that the law intends to protect. So in this case, which is a woman and her safe workplace for her. So therefore, what when the law says that you have to file it within 3 months of the incident, or the last incident, if there is a series of incidents. The last incident, to my mind, can also be, for example, sometimes what happens is that if we're talking about someone that propositions a woman, and then she says no, etc., and he propositions her again and she says no. So somehow there is a series of incidents, but subsequently what happens is that there is a retaliation, and she can experience it in her work. Okay?
Understood.
Then, which therefore creates a hostile work environment. So to me, even though the proposition or the incident of sexual harassment itself may be 3 months back, but the creation of a hostile work environment, okay, which is connected and related to the sexual harassment, happens a little later, then that also can be the point from which she files her complaint.
Understood.
So that is one. Two is that, okay, sometimes there are situations where, you know, he's the woman's manager, and there is a sense created that he has a lot of power with the management, etc.
Right.
So women don't feel safe to actually file this complaint, and they continue to be in a very intimidating or a hostile work environment. And it may be such that after a point he either gets transferred or moves to somewhere else, or you move to some another place. So then a sense of there is you get a sense that, okay, now possibly I could file the complaint. So then the woman goes to file that complaint, and then I think women ought to, okay, whenever you feel that this has happened and you want to approach the IC, you must, and don't limit yourself by a very technical interpretation of the law, okay, and leave it to the IC to a certain extent, and explain your position and say why you could not think. And the IC also at this stage must not look at it as very technically. You know, it's not like a breach of a contract between two companies or between two equally placed people. So therefore, then yes, under the law, 3 months from the last incident can be interpreted to mean hostile environment also. And the IC has another 3 months that they can do. So therefore, it is a 6 month period, and the IC also must read this law a little more flexibly rather than rigid.
Absolutely. So, of course, while we expect ICs to do the right thing, but purely from the perspective of a complainant, I would always say that just ensure that you're on 100% within what the law says, as an abundant safety measure. But of course, if for any reason you couldn't file it within the first 3 months, that's all right. Go ahead, file it, explain to the IC why you couldn't, and as Veena says, most ICs will accept that and allow the complaint to be heard. Veena, you made a very good point, which is that any kind of retaliation or victimization is a continuation of the sexual harassment, and therefore can be treated as the last incident in a series of incidents. So those who are at the receiving end of sexual harassment must remember that even if the incident the incident of sexual harassment happened 3, 6, 9, 12 months ago, But if the victimization and retaliation is ongoing and continuing, then you have a right to file a complaint of sexual harassment, and you will be still within the period of limitation as per the law.
Yes, and you have to mention as to,
Of course.
yeah, so that the committee also has reason enough to accept your complaint.
Understood.
When it happened, why didn't file, and how there was a continued harassment. So you must have those details in your
details ready. Okay, and we are in fact, that's what we're going to cover very shortly in terms of what are the details that that must be there in a complaint that is filed. All right. So moving on, what are the essentials of a complaint? We have listed out a few things that we believe are very, very important and that must find its way into the complaint. If you are filing a complaint, please bear these essentials in mind. It must contain the details of both parties and the nature of relationship between the parties. Details of both parties to the extent you know. Of course, if you do not know who the respondent is, or if it could be an anonymous stalker, or it could also be somebody who works in the complainant's office, but you do not know who that individual is. That's all right. Share as much detail as you can. Of course, if you know the individual or who is the respondent or the harasser, then share as much as you can. For example, if you know who the individual is, their employee ID, etc., or email ID, anything that is unique and that can help the IC identify that individual, please feel free to share that with the IC in the form of the complaint. The other thing that must be borne in mind by the complainant when they're filing the complaint is that provide details of the incident or incidents, highlighting the sexual nature of the conduct in a chronological manner. So the idea really here is to be as systematic as possible, put down the details of the incident one by one, and in a chronological order that shows the IC that you have logically put the sequence of events down, right? And feel free to share as much information as you can. In fact, the more information that you share, the better. Although don't view it as a negative if you're not in a position to share too much. But we always recommend that if you give enough information, then it makes the IC's task of investigating that much easier. Be very specific. Remember to mention the language that is used, the physical conduct, if any, if applicable, if there was any physical conduct, dates, time, venue, all of the nature of the incidents. All of these things must be specifically brought out so that the IC can actually move this. When they're taking on the complaint, they get a full idea or a full picture of what really is the meat of or substance of the complaint. If there has been any consequent hostile work environment, as Veena mentioned a while ago, which is basically in the nature of any kind of retaliation, victimization, which, to put it simply, if there is any revengeful action that is being taken by the respondent or the harasser, just because the complainant has turned down or rebuffed any advances that were made, that would come under what we call, or what the law calls, creation of a hostile work environment, and that is a continuation of the sexual harassment that has been faced by the complainant. Very important to actually list down the witnesses, if any. So again, don't feel pressured if there are no witnesses, but if there are witnesses, put all details of witnesses along with why they may be relevant to the complaint. For example, if somebody witnessed an incident of sexual harassment that happened in the office or at a party or anywhere, then they become witnesses in your complaint, and put details of those witnesses in your complaint and give an explanation of why you believe so-and-so person has to be a witness in this complaint, so that the IC has more context in that sense, right? Lastly, if there is any kind of supporting document, evidence, emails, screenshots, WhatsApp messages, think of whatever it is that could support or aid your case, then attach that along with your complaint to bolster or strengthen your case. So that's in a nutshell what the essentials of a complaint are, what should kind of find its way into any complaint of sexual harassment that is filed against a respondent with the internal committee of a company. Veena, anything more to add to that?
Yeah, like I said earlier, the law the law is in place to assist women and to help women and to ensure
Right.
that they have a safe workplace. So therefore, it need not be, it's not meant to be very technical in
Sure.
that sense. So please, when you write your complaints, remember that, you don't have to be too worried about the legality or the technicalities of it. Just write experiences are, and like he said, if possible in a chronological order. But what you must remember is sometimes what happens, you don't have evidence. So therefore, your statement against the other person's statement. So therefore, it's essential that your complaint is a little detailed. Women are reluctant to actually write the details down. So many of them will say, like I said earlier, he used abusive language, and not necessarily say what that abusive language.
Right.
I think women must law must also be an empowering process for women, and this right has been given to us. So let's use it and let's find the strength to use it. So therefore, not hesitate in a way. I mean, if the person has not found, he's not embarrassed to say it or to do it. I think women should also at least find the strength to actually write it down. So what those abusive words were, it may not be a word that some of us use in our everyday life, but it's essential and it's important to write those things. When you say, okay, he touched me, he did whatever that he did, to write those details of it. Because sometimes, like we said earlier, certain times when we write the complaint, it may not come across as in the nature of sexual harassment, because there's nothing really much that is there for the IC to go by. So it's important to write that. Use the language as it is said in the slides. And if you can, sometimes date time may not be so easy to remember or recollect. That's okay. Just remember it as far as possible, 2 months back, 3 months back. If you can, then write the dates and time, etc. But just because you don't recollect that doesn't mean then that, that should not lead you to believe that you ought not to file a complaint.
Sure.
Write your experiences, come from there. And yes, like he says, that any supporting documents or list of witnesses, I think we'll come to the later part of it in more in detail as to what the witnesses and the supporting documents are. So the idea is to be able to put down your experience as is and with as much clarity as possible.
Understood. So in a nutshell, if I could sum up the key aspect, I think that you mentioned, Veena, is be as detailed as you can and don't feel shy in being detailed, but don't let it stop you from filing a complaint if you feel you are not able to express yourself in writing as well as you would like. So if you want to give lesser details, that is still okay. It bolsters or strengthens your complaint if you give more details, but in no way does it should it prevent you from filing a complaint if you want to be a little sort of frugal with the details in the complaint and substantiate it later in an in-person face-to-face hearing with the IC.
Yes, you can do that, but at least some substance of it must be there in the complaint. Some kind of you refer to it,
as much as you can.
Yes, because otherwise the possible defense could be that she's improved her case at a point in time. So even if sometimes you're not hesitant, at least put as much as you can in that complaint.
Fair enough. All right. So that's basically what we call the essentials of a complaint. Now, just a couple of things to remember for all of you. During the process of the IC hearing the complaint, they also have the right to award what is called interim relief. For example, if the complainant has been sexually harassed by a manager or by a colleague, it is all right to ask for interim relief in your complaint itself, which is to say that request for a change in your team for the duration of the case being heard, or change of seat. It could be also something as simple as a change of seat or change of transportation that you take every day to office. No interim relief that you ask for is too small, right, or insignificant. The IC is here to help you. So if you feel that you need some relief pending the IC hearing the case, don't be shy to ask for it, and you can put that down in your complaint as well. Then the other aspect that is important, and that all of you must bear in mind is with respect to evidence. When you're writing your complaint,
can I just come in
yes,
here, Alex?
yes,
Yeah. Now
please.
about the interim reliefs, yes, in your complaint, when you file your complaint, you must remember, as we've said earlier, that this complaint, a copy of it will be sent to the respondent, to the
Right.
person against whom you file this complaint. So a lot of times, I mean, you may fear that there will be retaliation or, etc. And it's also very difficult once you file the complaint to actually be working under the same person, or the situation will be such that you may have already stopped coming to office, so whatever it is.
Right.
So the inquiry takes a little bit of time. I mean, the IC is being given 90 days to finish the inquiry. So within that period, the woman would be in a kind of a hostile or an uncomfortable situation. That's why you have the concept of interim relief. So
Right.
in your complaint, if you want, you can ask for those interim reliefs. If you haven't, the first time you speak with the IC also, you can tell them that this is your situation. Now, like he said, the interim reliefs could be, one is that either you can ask transfer, or you can ask for him to be transferred. You can ask for leave, but this will be a paid leave. It will be not considered as part of your otherwise the leave that you're entitled to. And or you can say that he will not come to office. And like Alex said, it could be change of place. If there are a couple of buildings from where you're working, then you could be shifted to another building. So you can, in a way, ask what is that relief that will make the woman feel secure during that period of inquiry.
So all options are on the table, and no relief is too big or too small to ask for. And you should document it preferably in your complaint itself. But even if you don't, and it strikes you at a later point of time, a complainant can still go to the IC and say midway through the proceedings and request for interim relief. That's also on the table,
yeah,
right?
Or
That's,
in the first contact, the complainant has also that can be
fair enough.
I mean, at some point, what happens is that sometimes that certain requests that one makes may not be practical.
Right.
So we also have to then work with the IC to see that, okay, what's the best possible solution in that given circumstance.
So the interim relief is at the discretion of the IC. So a complainant can ask for it, but the IC has to feel that the request is reasonable and justified, and then pass an order, right?
Yeah, it says may recommend. So of course there is a discretion.
The final decision is that of the IC.
Yes, again, the spirit of the law must be seen. The spirit of the law is to ensure a safe workplace for women. Yes.
Right.
So,
okay, the second aspect is with respect to evidence, which is basically when you're preparing your complaint, try as far as possible to ensure that you've put as much evidence as you can. Now, sometimes when we are in a difficult situation, it may not strike us that someone may have witnessed it. They could be a witness to the incident, or is there any kind of electronic evidence that I can use? So cast your mind far and wide in terms of seeing if you have any kind of evidence that can be used specifically with respect to filing the complaints. So think about whether anybody who witnessed the incident, is there any kind of electronic evidence, email, WhatsApp, CCTV, etc. Did the complainant speak to anybody about the incident, or immediately after the incident, or even sometime after the incident? Has the complainant spoken to somebody, confided in somebody? These are all important things that little things that can actually, if they are properly documented in the complaint, can significantly strengthen the complaint or the complainant's position as brought out in the complaint. Anything else to add to the evidence piece, Veena?
Yeah, one is that, see, uh, violence against women, I mean, in situations of violence against women, it's always very difficult to get direct evidence. I mean, no one beats a woman when someone is looking at you, or no one harasses a woman when you're looking at you. So therefore, to a certain extent, the law understands that, and the law has evolved to kind of understand that. And the law has also evolved certain mechanisms for that. So therefore, I mean, this when I'm experiencing sexual harassment, I might as well believe that I'm not the only one,
Right.
and so therefore mine will not be the first complaint. So the law and the ICU hopefully will understand. Therefore, not having evidence or not having witnesses should not stop a woman from filing her complaint. And that is the reason why we said in the beginning that in your complaint, as much details as you can, because at some point it becomes your word against the respondent's word. When there are details of complaint, the IC, the law requires that the IC should consist of senior members of the company. The reason is that also is there is a certain wisdom, there's a certain experience, and you do hope that IC members will stand for what the spirit of the. So they are also able to understand. I mean, it has a majority women, the IC is supposed to be, so that experiences of women also come into this whole inquiry process. So therefore, one is that the law understands it, IC hopefully understands it too, and normally, usually the situation is that there is no direct. So that should not be a reason for women not to file a complaint. One. Two is that what is this evidence, like Anthony said, that one, I mean, it could be direct witnesses who were there when a comment was passed. If someone says, oh, you're looking really sexy or hot today. So other colleagues heard, they would come and they could be named in that complaint. The second thing, something happens to you and, you're upset, you run to the restroom and you're either you're either crying or look very frazzled, etc. So someone asks you what happened, you may or may not tell them what exactly happened, but even the fact that someone has witnessed that that gone,
you're running out, yeah,
would actually be witness enough to say yes, she looked upset and she looked disturbed. So that could also kind of corroborate your allegation of sexual harassment, though you don't have a direct evidence. So that person also could be a witness. So it doesn't have to be someone who's directly witnessed it, but who can corroborate a story. For example, if you're doing extremely well at your work or whatever that it is, there's a certain consistency in your work. Suddenly, after instances of sexual harassment, you see that your ratings or your work is being reduced or too much. So people around your colleagues are also able to give evidence to the effect that yes, you're suffering. I mean, there is a hostile work environment towards you. That much more in meetings than you were earlier. So all this can also be witnesses and people who could corroborate your complaint. And help you substantiate that complaint. So you have to, like Anthony said, think a little carefully on who your witnesses and evidences could be. And like he said, WhatsApp messages, etc. What is there in the slide? CCTV camera footage. Sometimes, if you're seen running out of the room or you've seen that person. So all this can be evidence, and you don't have to worry about whether the witness will come, or do you have to call the witness, or how can I get the CCTV footage, or how will I get my assessment document or my project, whatever. The IC pretty much has the powers of court when it comes to calling for witnesses and evidence. You just give your name and the documents that you want to call for, even if they are in the possession of the company, then the IC will call for it. They
Right.
will call the witnesses and say, okay, you have to come and give your statement. They can write to the management and say that, okay, produce these documents before us, and the management is bound to produce those documents. So don't get stressed and harrowed by the process itself. One, write your complaint, write the details of it, see who are the witnesses and evidence that you can write there. The entire burden is not on you to carry that complaint. The IC also has to bear a little bit of that. So remember that when you're drafting your complaint.
Okay, all good points, Veena. Thank you. I think those are really sort of very key points that one must bear in mind while drafting a complaint. And of course, basics, keep it simple. Language should be simple and clear, very crisp, state relevant facts. Now, sometimes a complainant may not necessarily know what is relevant or what is not, or may not be in a position to, may not want to make that decision, but don't worry, put in as much as you know. Even if you feel that it's not directly relevant, doesn't matter, put the information in, let the IC decide whether it's relevant or not. But do not keep out facts because you feel that it may or may not be, or if you have a doubt, include. I would say if you have a doubt about whether something should be in the complaint or not, better to be over-inclusive and include. Veena, is that something that you'd agree with?
Yes, I would.
Okay.
I mean, it's better to err on the side of writing,
Sure.
Whatever that we think is then not. So yes, keep it simple, keep it clear, and write what you think is relevant in this.
Fantastic. So that is, in a nutshell, a summary of what really should find its way in a complaint. Of course, we could, Veena and I could probably spend another 2 hours talking about this. But, this is a webinar and we have to make sure that we're able to get the information to you in a crisp and concise manner, stating only what is relevant. As you've seen in the previous section, we have managed to cover all the essential ingredients of filing a complaint under the POSH law 2013. The second part is going to, we have 3 case studies for you, and we're going to walk you through those case studies. They're illustrative in nature, just to give you, the prospective complainant, an idea of different types of situations that others have found themselves in. And we've got Veena to sort of guide us on what would be the appropriate step in the event something similar to this happens to them. So let's just pick up the case studies one by one. As I mentioned, we have got 3 of them for you. So the first one is the names of the 2 characters are Mithali and Raj. They're all fictional. So even if there is a Mithali or a Raj, please don't assume that it's named after them. This is all completely fictional. All right. So Mithali and Raj work for the same team at a top international bank. Raj has managed to get hold of Mithali's phone number via common colleagues' friends and is now constantly sending her WhatsApp messages. He has also been sending her friendship follow requests on Facebook and Instagram. Mithali has requested Raj time and again not to contact her, but Raj refuses to pay heed to her requests. So can Mithali file a complaint with the IC for sexual harassment? What should the complaint consist of? And what can be considered as evidence? Veena, over to you.
One is, I think my understanding is that the reason for giving this case study would be, one, if you notice here, there is nothing that, where Mithali has said that there was any sexual proposition made, or a sexual, or a touching, etc. It's this constant messaging for friendship. And though she says that she's not interested, he continues doing this. Now, one thing we must remember is that when we are in a work relationship, it is a formal relationship, and it's a workplace relationship. So anything that is a little outside of that, and which is unwelcome to the woman, and which is persistent despite her saying that I'm not interested in being friends with you, to that extent it makes, because the point of view is from the woman, so it makes her uncomfortable. It is not work related, it is persistent, etc. So therefore, seeking friendship, then yes, I would think that it would come under sexual harassment, and she ought to file a complaint. Now, the thing is that when we look at it, and if someone hears me, they may say, oh my God, it's something so simple, and she's saying that this amounts to sexual harassment. And now, if there is a complaint of sexual harassment, it doesn't mean that for all complaints, the person will lose his job or, will be demoted, etc., etc. Now, so now this may be seen as something that is not very grave. So the committee will also look at it like that. So,
Right.
for example, it could be possibly in India, especially, we fail to understand that when a woman says no, it means a no, because that's not what socially, culturally, through Hindi cinema that we are taught. We're taught that if you persist, then the woman at some point may say yes. So this could be that kind of a area where men themselves also don't understand how you negotiate this case. So that will go before the IC. She has all the WhatsApp messages, etc. And the committee might feel that yes, this amounts to sexual harassment. And the thing could be that, they say, okay, ask him to apologize or reprimand him for this. So that also could be a possibility. Or ask him to go through a session of gender sensitivity, etc. So yes, this would amount to sexual harassment, and one should not worry about what the gravity or the intensity of it, because punishment will be proportional.
So it'll be treated, the offenses, even if you feel, even if one feels that the intensity or gravity is not very high or serious, but that it does constitute sexual harassment nevertheless, and a complaint should be filed. Of course, as you rightly said, Veena, the punishment that is given depends on the gravity or intensity of the offense, and therefore the IC will determine punishment according to what the gravity or the intensity is. Fair enough. And Veena, what would be evidence in this case? All the WhatsApp messages?
Yes, WhatsApp, Facebook account, Instagram, all the the requests that invite.
All the persistent requests over time would amount to evidence as well. And if Mithali has kind of spoken to any of her friends about the persistent harassment by Raj, that should also kind of find its way in the complaint, right?
Yes, that would. But, so when he has sent these requests and she has said no, all of that will be available to her. So one could give a printout of it or forward it or attach it to the complaint and send it.
Okay, fair enough. So that's Mithali and Raj. That's our first case study. Moving on to the next one, Sonia and Rahul. So Sonia and Rahul are colleagues who were at an offsite in Goa. At a party at that same offsite, Rahul kept trying to put his hand around Sonia's waist and get close to her on the pretext of trying to dance with her. In spite of Sonia's repeated requests to Rahul to leave her alone, Rahul kept trying to get close to her. Sonia, feeling harassed with the ordeal, confided in Simran and Vijay the next morning about Rahul's behavior. After returning from the offsite, Sonia received WhatsApp messages from Rahul asking her out on a date, and also started showing up at her work desk, trying to make small talk. Sonia conveyed to Rahul that she's not interested in him, but Rahul refuses to stop. Sonia now wants to file a complaint of sexual harassment against Rahul before the IC. What should Sonia include as evidence in her complaint to the IC?
So one is that, of course, she will start with the fact that they went to Goa. This is what happened in the party. If she can remember who all were there at that point in time when he was trying to, put his hand around her waist, etc. So that will be one part of it. Second part here is that Simran and Vijay will also be her witnesses, because the very next day she tells them what happens. So they will corroborate the fact that yes, she told us immediately thereafter, which was the next day. Now, if possibly, if she has told Simran and Vijay 3 months later, it will not be the same. But the fact that she tells them the very next day would be a strong evidence to corroborate and support her case. And the fact that when he's coming to her desk, etc., if there are CCTV camera footages of seeing him coming there, if her colleagues who are sitting next to her, all of this would be evidence, and she has to state all of these. So for the party, etc., she may remember the exact dates. She may not remember the exact dates when he came towards her desk, etc. So she need not worry about that if she can kind of. And it's also important, maybe taking this case as an example, that if it could be a suggestion to women, saying that when something like this happens, the first time, and you're not willing to, you don't want to file the complaint, maybe it's better to make notes, every time some incident happens, so that when you want to file a complaint, it's available for you. If at the first instance the woman is not willing to file the complaint.
And if you can share what's happened with you with one or two people in the office or friends or colleagues, I think that also kind of goes a long way in strengthening the case. They become potential witnesses.
Yes, but I mean, to that extent, that sharing ought to be a more natural process.
Of course, yeah.
So that's why I said that if she's immediately told them post the incident, then that would help.
Good.
But if she tells them a couple of months later, then it may not be as strong as evidence as this.
Fair enough. Okay. Terrific. So that's Sonia and Rahul, and then let's move on to the final one, which is a little more, I guess, the kind of cases that we typically tend to see in a lot of organizations. Sejal and Jignesh. So Jignesh is Sejal's manager at a top-tier jewelry design company. Jignesh has on a number of occasions made inappropriate comments on Sejal's appearance, asking her to wear dresses which show off her great figure. On one particular occasion, when they were alone in a meeting room, he had tried to touch Sejal's shoulders on the pretext of giving her a massage to calm her nerves. Sejal now feels insecure working with Jignesh and wants to file a complaint of sexual harassment before the IC. Sejal has no witnesses to substantiate her complaint. Can Sejal file a complaint without any witnesses or documentary evidence? Veena, and this I think is fairly common, right? It happens in a lot of organizations where the complainant has really no evidence, so to speak, and is often caught in a situation where she's wondering, should I even bother filing a complaint because I really have no evidence to put down in my complaint. It's a classic he said versus she said kind of situation. So what should somebody in Sejal's position do if they need to file a complaint? What should they be doing?
See, we've kind of covered this earlier also, where we say that, I mean, harassment, etc., does not happen when there are direct witnesses, and the law understands it. The IC must also understand it, and women on this ground should not hesitate from filing a complaint. In such complaints, it's essential that the details of it are quite important here, because it's only your statement against his statement, And if the woman is able to be consistent in her complaint as well as in her statement before the committee, as well as in when the committee asks you questions or during cross-examination by the respondent, etc., if the woman is able to withstand that cross-examination.
Thanking everybody for sort of patiently spending an hour and going over our sort of webinar today with Veena. We have a bunch of questions, Veena, so I want to kind of sort of just go over them one by one. I'll start with the ones which have come in the open questions. Mona is asking that the offender is careful now and unsuccessful attempts results in him playing politics to demoralize the victim or show his powers, leading to finally the woman being compelled to leave the job. So does this fall under POSH and a legitimate complaint under the POSH Act under POSH to the internal committee? Veena.
Yes, I think we've discussed this also. This would lead to hostile work environment because, I mean, he has created that situation whereby she leaves. There have been instances where women have filed cases even after they have left. Yes, it would amount to sexual harassment and she should file the complaint.
Mona, yes, it amounts to sort of sexual harassment. It is basically creation of a hostile work environment, as we had discussed previously in the webinar. So it amounts to a hostile work environment, and a complaint of sexual harassment can be filed with the internal committee. Okay. So a woman refuses to give. Asavri is asking, a woman refuses to give a written complaint. but constantly complains verbally, or sometimes it's visible that she's getting harassed. Can IC file against her? Or do you? I think what Asavri means is that the IC can file a complaint on her behalf, maybe. Um, so, is what's your view on this, Veena?
One is that I think what the law expects is that if the woman, I mean, does not file and she merely raises this issue, then the IC must kind of encourage her and support her and give her the confidence enough to file that complaint and to get her to trust the system. One. Two is that despite which some of the women raise concerns, but they say that deal with it, but we don't want an inquiry to be done. Okay, and there are a couple of principles that are applicable here. One is that, like I said, the respondent has a right to know and defend himself. So it will be unfair if there's no complaint. The second is that to that extent, on individual cases, I don't think the IC can suo moto take up cases. Because the woman has to finally come and give her statement. If she doesn't, if she refuses to, then there will be no purpose to it. And it could be that, the man feels that there is some kind of a hidden agenda of the IC. The third thing, and one of the most important things for me, is the agency of the woman. Okay, a lot of times in the kind of patriarchal societies we live, as fathers, as brothers, as male friends, we always tend to take on, the problems of the woman and say you must fight this. But the idea is that the woman must agree to fight that. So it must be always her agency. So it is as important even in the sexual harassment complaint that we must give her enough confidence, enough courage to file that complaint. But if she refuses to file that complaint, then that call is hers. And we must remember that the agency of the woman must always, to me, very important that it is protected. And three is that she may have other consequences that she may not tell you. I mean, a lot of times women tell you that the minute if I tell my family that there is a situation like this, they'll ask me to leave my job. Even in India, even as of today, a woman working, unless you're of course augmenting, adding to the income. I mean, in certain other situations, it's still a fight for her. The fact that she's working, all that has to be considered. Yes, the woman has to file a complaint. Can't suo moto kind of take action. And in these circumstances, what we do is that, for example, earlier it used to be called internal complaints committee. Now it is called internal committee. My reading of it is also big that we don't only, so something is happening in this situation, the woman is refusing to file a complaint, then I think there must be some kind of other intervention by the IC, which could be conduct a training session, I mean some kind of sensitization session for that department or for that group.
Fair enough. So yes, in short, the complainant or the woman must, aggrieved woman must file the complaint. There's clearly no way around that. Shalini Nair is asking if the complainant does not have any evidence. Sorry, suddenly, yeah. Is asking if the complainant does not have any evidence like witnesses or documents, does the burden fall upon the IC to conduct fact finding?
One is, I think we've kind of covered it. So then it is your case against her. I mean, her word against the respondent's word.
Correct.
Now the IC, I think it's a very restrained kind of a thing. Yes, the IC can say, okay, can we ask this person or that and give a suggestion, but can't, in a way like a police investigation, go around and digging the situation. Because I mean, sometimes what happens is that you go there and I mean, you start looking for evidence. I mean, in a way, go against the woman herself. A lot of times you'll get evidence saying, she's that kind of, I mean, she's the one who kind of asked for it. This is the way she dresses. This is the way she works. I don't think, I mean, IC has to be very responsible. It can't go after somebody in that sense. There should be a reference to something in the complaint that they can then call for. But the woman should be made aware. this can't be done behind her back. Because a lot of times, I think this is very important question, Alex, is because a lot of times what happens, I have seen when people have asked for my advice, when a woman files a complaint, then what the IC does is that the IC will ask either the HR or someone that the IC delegates to conduct an investigation. Based on that investigative report, the IC passes an order, and I think that is not correct, that is not fair. Both parties have to be aware as to what is the evidence that is before the IC and what will it be finally that the IC will be considering, the evidence before it. So therefore, yes, if they want to, they should inform the two parties and say, we would like to call this person, etc., and can't kind of on their own go digging into issues.
Right. So moving on, I realize there are lots of questions, so I'm going to move quickly. Asawari is asking if the offender is female and the complainant is male. Would the same be considered for a complaint before the internal committee or the internal committee under the posh law?
Unfortunately, fortunately, the law is called Sexual Harassment of Women at Workplace. Okay? So the complaint has to be filed by the woman. I don't know how many of you are lawyers here, but this is what we call 15(3) affirmative action kind of a law. It applies to women as a certain marginalized section and oppressed section of the society. That is one. Two is that, so that's one, so it has to be filed. Now, if there is, then if the sexual harassment law doesn't apply, then you have your regular HR policies or whatever harassment that also can be accessed by the man. But and the interesting aspect of yours is here, if the respondent or the perpetrator is a woman against the woman itself, for example, there can be any kind of suggestions made. Oh, you're so slutty, or this is the way you're dressing, and this is what. So there could be certain comments which would upset a woman. There is a judgment of the Supreme Court which says that the respondent under the Sexual Harassment Act is a person. So therefore, there is an interpretation that yes, it can be filed against a woman too. However, it can only be filed by a woman.
Correct. So to sum up, a man obviously cannot file a complaint under the posh law. It has to be a woman, but it can be filed against the respondent can also be a woman. That's not a problem. But the complainant, under all points of time, must be a woman. That's what is called affirmative action. It's one of those laws that the Parliament has passed to support a sort of in support of women. So that is that particular issue. Moving on, Himanshi is asking if the complaint is maintainable if the complaint has been taken up by the committee or the IC after resignation of the complainant.
I think we just mentioned that. Yes, it would be my reading of it.
And
because what is important here is that the respondent still works. For example, if the respondent has left and the complainant is still working, then the IC may not have much of a role because they don't have the power to pass any orders or recommendations against the person because the person is not working there. Another aspect we must remember is that IC is not the only way. We have 54 of the Indian Penal Code where sexual harassment has also a criminal offense. So if no other option is open, one can also file a criminal complaint.
That is true, but Veena, in the event the respondent was an employee and has quit, the IC, of course, if it has started investigation, they are obviously well within their powers to complete and conclude the investigation and even pass an order. After all, that IC has the powers of a civil court. So even if the employee is no longer an employee, the respondent is no longer an employee, the IC should still go ahead, hear the case.
No, if the complainant is not an employee, yes, they can. But if the respondent, for example, if he's in the notice period, then, for example, you can withhold whatever till the inquiry is concluded. But if he's already left, then I won't think that's possible.
Okay. So Vidhi is asking if the offender is one of the clients of the organization, could that also come under the ambit of complaints to the internal committee?
Yes, it does. In a sense, for example, if that client is also working in some space, in some workplace, I mean, so therefore, what happens? The woman files a complaint to her internal committee. To me,
Right.
your internal committee can actually refer this complaint to the respondent's company. Okay. So now the thing is that because then the that internal committee could conduct an inquiry, but the fear could be that what if they try to hush it up, etc. You may not have faith in them,
Correct.
but one would only hope that everybody would be true to the spirit of the act. Because the issue here is that even if your IC, the woman's IC, were to conduct an inquiry and pass certain recommendations, then the client company may not actually implement. Then, of course, it lies on the company of the woman herself to say that then we would not have any relationship with them, whatever that it is. Or, I mean, I have been in situations like this where, for example, the complaint has been heard by the IC of the woman, and the respondent's company has given an assurance that they will implement, and they have implemented. They have also actually had a person come and being present during the inquiry so as to ensure that a fair process is followed. It could be done another way, the other way around too. But these are slightly difficult and complex situation, and it depends on the intent of both the companies.
Yeah,
However,
these
yeah.
are
However, for example,
definitely
if you're in a bank,
tough and
and an account holder comes into the bank and does something, your IC may not be able to look into it because they don't have any powers for a customer or whoever that is the thing. Then it would be 354 of the IPC, I would think.
Joseph is asking Veena, what should an employee do when the perpetrator
The law is
is the
pretty clear
promoter
on
or
that. There is
owner of the
something called
company?
the local complaints committee. Under the law, at every district
Mhm.
level, the government is supposed to
Correct.
set up local complaints committee. And wherever the complaint is against an employer, then the power is given to the local complaints committee, which has its own, its own members. For example, then the government sets up people from NGOs, people from within the government, and etc. Are
Correct.
there. In Bombay, for example, where I'm speaking from, we do have a LCC, as it's called, a local complaints committee, but not all states have set it up, and one must pressurize the states to actually set up these LCCs. But against the employer, then it goes to the local complaints.
Correct. Local committee, correct. I mean, there's a clear provision in law as well where it says if the case is against the employer himself, then the complaint must be filed with the local committee. So Raju Chug is asking, is there a predefined action based on the severity of the complainant
I'm
of the
sorry, there is
complaint,
an echo.
or
Can
this
you?
discretion of the management? Yeah, I'll repeat my question. Raju Chug is asking, is there a predefined action based on the severity of the complaint,
One
or
is
is
that
this
there are two
discretion
things
of the
that apply
management?
here. One is the service rules of the company itself and what the service rules provide, if there's any kind of punishment that is provided. Otherwise, the law itself also speaks of it, which is Rule 9 of the rules under the Sexual Harassment Act, which says that written apology, warning, reprimand, censure, withholding of promotion, withholding increments, and termination, etc. So it is to that extent whatever is applicable in your labor and your service.
Right. So we still, the questions are continuing, but at some point in time we'll have to. I think we'll take a few more, and then we'll have to call it time on this webinar. Himanshi is asking if the complainant refuses to attend IC hearings, but keeps on raising questions about the integrity of the IC and softly abuse it. Can
No,
the
I
IC
mean,
issue
the
contempt
IC has
against the
powers of a
complainant?
court, but is not really a court in that sense, so can't issue contempt. But one is this, that the law
Yeah,
says
I can
that if
issue
the
contempt
IC
notices for sure.
issues notice for the parties to come, and if the complaint then doesn't come on 3 occasions, then they can close the complaint as saying, not prosecuted, etc. One. And
Yeah,
two is that there are situations where
correct.
sometimes you feel that the members of the IC could be biased. Either they know the respondent, etc. And if the complainant raises these issues, the IC must take them a little seriously and ensure that that fear that the woman talks about is kind of resolved. So then maybe one of them steps out saying that,
Right.
okay, this is because I'm connected to the case. Contempt, no, but if she doesn't come before the committee, yes, you can say that we have sent notices, but you have to give clear notices saying, come on this day, give her enough time, and only if she doesn't come, give reasons, and then close saying that she didn't follow it up.
Of course. Give her adequate notice and adequate opportunity to appear before the IC before you dismiss it. So that's fair enough. Rana Bomik is asking, what is the role of group internal
That
auditor
I
in
think,
implementing
Alex, maybe
POSH in
you
an
could
entity?
answer, but otherwise, what the law envisages is that you have to give an annual report. So to the government to say that you have an ICC, how many complaints did you receive, how many workshops did you do, etc. So it is something, and there are punishments that is there as part of the law for companies that are not complying with the POSH.
Yeah.
So therefore, to that extent, as a compliance of corporate responsibility, yes, they will have to ensure that the IC is set up and the IC is functional. Workshops on the law and awareness on this law has to be created on a regular basis. If one wants to go one step ahead, I feel it should be part of the
Right.
contracts, employment contract, where it says that the company has zero tolerance to sexual harassment, and that it could be a ground for be taken again.
Yeah. So, Rana, I mean, I think Veena's pretty much answered your question, but really, the group auditor's job is to flag out any issues in case it comes across those issues in compliance with the law during the course of its audit. And the Prevention of Sexual Harassment Act 2013 has quite a few compliances listed out, including formation of the internal committee, carrying out its orders, filing the annual report. In fact, there is a report that needs to be filed at the end of every calendar year, and there's also a statement that needs to be made in the annual returns that are filed with the MCA. The auditor's responsibility is to ensure that each and every sort of one of these points are properly captured in, and if they are not complied with, then highlight it and bring it to the attention of shareholders in its report. So that's really the auditor's responsibility in that sense. Sneha is asking, in case the company has no option of facilitating the interim relief, like department change or change of manager, possibly in small companies where the headcount is less than 15, how will we proceed? I mean, a common problem, Veena, that we have seen in quite a few companies, especially where the number of employees are very less, maybe 15, maybe
One
20, or
is
even
that
50,
you can
right?
ask the man to go
Typically in
on leave
startups.
or
How
not
should the
come to
IC
office.
proceed?
Two is that if the woman is okay, then you can ask her to go on leave as paid leave, and this will not be counted as part of her leave entitlement for the. So these are the other things that you could do. The idea of this whole is to ensure that
Right.
the woman doesn't feel like she's being punished. Because there was one more question that I saw someone had asked, saying that what if she doesn't agree for the interim reliefs, etc. Then I see that there is a problem. I mean, the idea is one of the first things that some of the ICs do is ask her to be transferred or something. She should not feel victimized for having filed the complaint itself.
Right. No, so I think it is critical that the victim doesn't feel further victimized for having filed the complaint. At the same time, the IC is able to arrive at an interim relief that is equitable, and in that sense, so yeah, a lot of options are on the table, Sneha, and I suspect that in many instances the internal committee will actually play it by ear in terms of the specific facts and circumstances of that case, and the of that and of that company as well. Different companies have different setups. So an IC, the advantage of an IC is it works within the functioning of that particular organization. So they know what that organization's drawbacks are, or what they can do, what they can't do.
Yeah, and
So
like
they
another
work
thing
within
is
that
that
framework
at
and
first
provide
instance you
relief
change the reporting. If the woman is
whatever is
reporting to the
possible within
man,
the framework of
and then
that
say, okay,
organization.
now she will not report to him. Assessments will be not done by him. So then you change that. Those are some of the options. Then you'll put a supervising person to maybe ensure in the situation.
Correct.
Leave. Ask them not to come to office. These are some of the other options.
Correct. And now the thing is that, of course, in smaller companies, Veena, that's a challenge to find, I mean, to change somebody's reporting in a 20-member company, that can be a challenge. But yes, those are all the options that are on the table, and IC will have to really consider everything. And here's where the expertise of an external member comes in. Remember that an external member has possibly sits on other committees as well and has experience and expertise in having handled similar cases. So, if the internal committee gets stuck at a particular point of time in terms of interim relief, many instances or on a lot of occasions, they can actually look to the external member for some guidance on what is the best way to navigate that particular situation. All right, so I think we will take final two questions. I know that on the chat there are still some questions, but we'll take a quick two more questions, and then we'll have to close the webinar because we are kind of out of time as well. So let me quickly pull out a couple more questions, and then we can
There was
where I
one
believe
that I
questions are
saw
kind of
someone
have
just
already
asked
been
under the
answered.
section 2,
I'm trying not to pick
etc.
those up.
Even a person not
So okay,
working
so there
with
is an
the company, can she file a complaint against someone working in the? Yes, yes, she can.
So I'm seeing one, Veena, I don't know if this is the same one. Anisha Giandani is asking if
That's a
the
very
offender is
interesting
not from the
question.
same
One, I would
office,
think
but
is
from the same
because
office
that building
building,
is
for
still my
example, will this
workspace.
come under POSH?
And so therefore the possibility is that
It is.
I
It
mean,
is.
one, he could be part of the security company, and you can file a complaint. Then, like I said earlier, then you report it to that company and see what action, and together you work out something. Two, the person could be working in another office in the same building. I mean, because if it covers transportation too, so obviously it will cover the thing. The idea is for you to reach out to your IC, and then
Yes.
then you work out how to how to figure this out. Like I said earlier, either that IC can do it. See, there's no law. I am someone who likes more interesting options. Well, what we need to do is that we have to understand, as long as the spirit of the law is followed, it's still a new law. It's possible that you could. I mean, there's no case law on it, but I'm just thinking aloud that from the two
Right.
ICs, a few of you sit together, have a joint thing, and work out and have a inquiry if possible.
Okay. So I mean, it's since the spirit of the law, as Veena says, is what most committees look at. That's probably what will happen in a situation like this, where somebody from the building ends up harassing the complainant. Again, my 2 cents is that a lot of times it also depends on the facts of a particular case and whether that individual ended up meeting the respondent, particularly in the course of work. Although, if you're working in the same building, then it does become the workplace for the complainant. But the law also does say that the one of the interpretations of the law is that the complaint should be filed where the respondent is employed. So, in that particular situation, the complainant may need to file the complaint with her own IC, and her IC might need to take it forward with the IC of the respondent to see if they can get her justice. Veena, there is another interesting question that comes up with respect to. I'm sorry, I seem to have lost that. Just yeah, will it be? And this is a question that I get a lot. So I think if you respond to this, it may be informative for a lot of people. Again, it's Anisha who's asking: will it be considered as legal for the complainant to
I
record
think it
voice
would
calls
be
or take
because I mean,
screenshots and share them,
unless
potentially as
the
evidence? I
guy
think is what
decides to file
Anisha
some
has
kind
in
of,
mind.
I think it would be because you're not a state or you're not an organization that is doing it. It's an individual interaction that you are
Yeah,
recording. I mean, for me, if suddenly my phone company or the government started recording, then I would have a problem. Individually, I think it's fine
correct.
because that's how you also kind of get evidence together.
There you go. So, Anisha and everybody else on the webinar, I hope that answers your question. This kind of
See, just if
screenshots,
there are
phone
any
recordings,
lawyers,
etc.,
I mean,
would all
sometimes
be
in a
allowed
court we
as
go by
evidence
65B
by an internal
certificate and
committee. I'm going
how
to
do
take
you
one
treat
last
electronic
question, Veena.
evidence, etc. Now here that I don't think that because there are no lawyers involved here, so that kind of technicality is not required.
Right.
For example, if someone gives a gives a screenshot, it's only fair for you to say that okay, show me the
Yeah.
original mail, can I connect it? Ask the respondent saying that do you admit this? What do you have to say about this screenshot? Did this kind of conversation happen? Sometimes because people delete conversations and they only have snapshots. As far as possible, you must correlate it to the original document or the conversation. If it's not possible, then you ask the respondent to. Sometimes, a lot of times, they do admit that yes, we had this and then see how possible is it for that person to have. It's not very easy to create this kind of electronic, whatever digital documents for a regular normal people. You will have to apply your mind.
Correct. Okay, so we'll take the last question. I think this is the final one. I'm sorry, we've run out of time. Nidhi Rani is asking, what if the employee writes something in her exit interview form? Should
Um,
that not be considered
Sorry,
as
I couldn't
written
hear, but
evidence, and
I
whether
read
the
the
company
question
becomes
actually.
responsible to
One
pursue
again
that?
is that it may not if it's written in the exit form, it may not be enough to
Yeah,
be called a complaint because a complaint has to be filed to the IC. My understanding is that by now corporates should be doing sexual harassment awareness, law awareness programs and workshops to everybody. This exit interview is done by your HR, etc. So if this is stated in your exit interview, then they must reach out and say that we do have an IC if you want to take this up further. But that is completely left to the woman, I would. Sorry, Alex, just one question which I think came repeatedly, which I
fantastic.
happened
Okay,
to glance through,
that
is
brings
that
us to
what
an end.
happens if they are co-workers but have
Go
gone
for
on a
it, Vinay.
social event that is not related to work? That often
Sure.
comes up for us. My yes, the very strict
Ah,
interpretation of it is that
that's
it
a good
ought
one.
to
Yeah,
have happened in the course of work. When I've gone for
it
a
does. It
meeting, when
does.
I've gone for an office party, or when I've gone. But I think sometimes what happens is, as colleagues, we've all finished working. You want to go out for a drink later in the evening. You go out, so it's not office work, but something happens there. There are two criteria as to how I look at it. One is that fundamentally my relationship with that person is of a fellow employee
Right.
or a co-employee. And therefore, to me, the relationship still continues to be that of a workspace. Second is that if I come back to
Correct.
work with this person, it also affects my workplace or hostile work environment, whatever. Yeah, it will affect my work. So therefore, just because it is a social event,
Very
it's not
much.
sufficient for an IC to say that we are not going to look at it. Because my interaction with that person arises from the fact that we all both work in it. Some people may not agree with this. There is, in that sense, I'm not aware of a judgment that is there on that specific issue, but I would look at it like that, and I think that's what we should. That ultimately, when they come back from that event, it does create a hostile work environment, and that interaction does lead to them. Yeah, that's something I saw. So therefore, sorry for that. Hmm.
Absolutely. Absolutely. I'm glad you put that up, Veena. It's a question that comes up very often, about where, how much is really the workplace? Where does it extend to? And so on and so forth. So I'm glad you've picked up and clarified that particular issue as well. It's something that, we have sort of explained in a lot of sessions, but I think this is one point that it's worth repeating, in the sense that we should reinforce what exactly the workplace is. So yeah, I think with that we will have to close the session. We have definitely gone beyond our time. So thank you all very much, and thank you, Veena, once again for this session. For the rest of you, do stay connected with us on LinkedIn. We will be posting an update with respect to when the second session will be, which is basically how does one file a response, right? So you have heard what a complaint, what needs to go into a complaint, and what a complainant must bear in mind while filing a complaint of sexual harassment. But what happens on the other side? What happens? What should a respondent be looking at when he or she is preparing a response to a complaint of sexual harassment that has come to them? We'll cover that in the second edition, and we'll come back to you shortly with the dates on that one as well. So keep an eye out on our LinkedIn page, and we'll come back to you with when that session is going to be held. Meanwhile, thank you all very much once again. Thank you for your time. Thank you for your questions, and for your participation in making this session a very interactive one. Thanks a lot, and we look forward to seeing you again.